All right, let's get right into it. If you're studying for your CA Foundation exams, you know the Sale of Goods Act is a big deal. Today, we're going to build your legal toolkit, focusing on conditions, warranties, and the all-important rule of caveat emptor so you can absolutely crush any question that comes your way. Okay, here's our game plan. We're going to start with the basics, what a stipulation even is, and then build all the way up to a step-by-step blueprint that you can use to diagnose and solve any exam problem on this topic. Let's dive in. We've all been there, right? You buy something, get it home, and it's not what you thought it would be. This is more than just a real-life problem. It's the heart of so many case studies in your exam. So today, we're going to unpack exactly what the law says you can do about it. So, let's start at the very beginning. Every contract of sale is built on promises, right? Statements made by the seller about the goods. That's our foundation. Now, when one of those promises is so important that it actually becomes a part of the contract, the law gives it a special name, a stipulation. But here's the crucial part, and you need to listen closely. Not all promises are created equal. The law sees a huge difference between them, and it sends you down one of two very different paths. And this brings us to a major fork in the road. This is the distinction you absolutely have to nail down. Is that promise a condition or a warranty? Because the answer to that question changes everything. Think of a condition as the absolute heart of the contract. It's the core reason you're making the purchase. Let's say you tell a dealer, I need a car that gives 20 kilometers per liter. That's the whole point. If they sell you one that only gives 15, the essential purpose of the contract is defeated. That's a breach of condition. And what does that mean? It means you can say, nope, deal's off. Return the car and get your money back. Now, on the other side of that fork, we have a warranty. This is more of an additional promise. It's collateral to the main purpose. It's important, yeah, but it's not the entire reason for the deal. Back to our car example. Let's say the car has a warranty on its music system. 6 months later, the speakers blow out. Annoying? For sure. But is it a breach of the main purpose of having a car? No. You can't return the whole car, but you can sue for damages to get the speakers fixed. Okay, exam focus time. If you only remember one thing from this chart, make it the right-on breach row. This is the whole shebang. Breach of a condition gives you the nuclear option. You can repudiate the contract. End it. Walk away. Breach of a warranty? You're stuck with claiming damages. That's the game-changing difference you need to know. So you're thinking, got it. Condition, big deal. Warranty, smaller deal. Well, the law loves a good plot twist. There are actually times when a breach of a major condition gets, well, demoted. It gets treated as if it were just a breach of warranty. A buyer has to be really careful here. You have this incredibly powerful right to reject the goods, but you can lose it. How? Well, according to Section 13, you could just waive it, basically say, don't worry about it. Or you could elect to just take the damages. A really common one is you simply accept the goods. The moment you do any of these, that powerful right to reject just vanishes. You're now limited to just claiming damages. Okay, let's zoom out for a second. What's the law's default position on any sale? It actually starts with a principle that shields the seller. This is the foundation for almost every case study you'll face. And this principle has a famous Latin name you absolutely have to remember for the exam: caveat emptor. You'll find it in Section 16 of the Act, and it translates to something really simple. Exactly, let the buyer beware. This means the default responsibility is on you, the buyer, to do your homework. Check the goods, ask the right questions, and make sure what you're buying is what you really want. The seller isn't required to point out every single flaw. So does that mean the buyer is just out of luck if they get a defective product? Is it always their fault? No way. I mean, think about it. If that were true, commerce would grind to a halt. So the law, very wisely, created some powerful escape hatches for the buyer. And these exceptions, these are the buyer's secret weapons. This is a legal toolkit we're here to build. For your exam, this is where you'll find the winning arguments for the buyer in most case studies. These are called implied conditions. The law automatically bakes them into the contract to ensure fairness. Let's run through the big ones. Fitness for purpose. You tell the seller you need a waterproof jacket for a monsoon trek, and they sell you a cotton hoodie. That's a breach. Sale by description. The box says pure wool sweater, but it's actually a blend. Breach. Merchantable quality is just a fancy way of saying the thing has to work like it's supposed to. A pen has to write. A kettle has to boil water. It's common sense, really. And here's a classic case that brings fitness for purpose to life. Priest versus Last. A guy buys a hot water bottle, it bursts, and sadly injures his wife. The court said, look, the chemist knew the purpose of a hot water bottle. The buyer was relying on the chemist's skill to sell him one that wouldn't, explode. The seller was held liable. Caveat emptor couldn't protect him.
And the protection for the buyer doesn't stop there. If you buy based on a sample, the huge order that shows up has to be just as good as that sample. And of course, if the seller is just straight up lying or actively hiding a defect, that's fraud. The buyer beware rule goes right out the window. It's all about ensuring a fair deal.
Okay, that's a lot of theory, but how do you use it when you're staring at a complex case study with the clock ticking? Don't worry, I've got you. Let's build your exam blueprint. Think of this as your diagnostic checklist. For any problem, just go down the list. 1. What was the promise? 2. Classify it, condition or warranty. 3. What can the buyer legally do? 4. Did the buyer accidentally lose their best option? 5. Is the seller going to hide behind caveat emptor? And 6. The final step, which exception can the buyer use to win the case? Follow this path, and you will hit every single point you need to for maximum marks. So let's end with a quick test. A customer specifically asks a dealer for wood best suited for doors and relies on their expertise. The dealer sells them unsuitable wood. Now, run this through our 6-step blueprint. The buyer clearly stated their purpose and relied on the seller's skill. So, which exception to caveat emptor is the buyer's winning ticket here? Mastering this framework is your key to unlocking this whole topic. Get this down, and you'll be ready for anything the exam throws at you.